So let me welcome all of you to this platform, my dear colleagues from across India. We have with us Mr. Rian Poole. He is a US patent attorney and a partner at MWZB. And Mr. Rian Poole, he was featured in the 100th anniversary edition of the Journal of Patent and Trademark Office Society. He specializes in patent drafting, patent prosecution, and portfolio management, patent design, and chemical and mechanical areas. He is a well-known expert in the international patent sphere, and he has developed expertise in the patent laws of many foreign countries. Recently, he happened to give a lecture at IIT Delhi, where I am a professor of electrical engineering. And we immediately got in touch with him and requested him to give a lecture to a wider audience across India. And he has very kindly agreed to be with us today. It is late evening for all of us. And for Mr. Rian Poole, it is morning there. I would like to thank all my colleagues, heads of institutions from across India, for joining us at this late hour for this very, very interesting lecture that Mr. Rian Poole is going to deliver. Friends, you know that as part of the implementation of the National Education Policy 2020, we have been encouraging our Indian higher educational institutions to work on intellectual property rights, to prepare appropriate guidelines for IPR within the institutions so that you can protect the knowledge which can be commercialized, you can transfer the technology, and you can encourage entrepreneurship among the students and the faculty members of the Indian higher educational institutions. We will hear more about the importance of protecting the IP and what are the legal procedures, and how by signing appropriate MOUs with industries and by developing this intellectual property rights, industry and academia can work closely and develop new technologies. So with those comments, I would like to hand over the speaker to Mr. Rian Poole to deliver his lecture.
Thank you so much. I appreciate the introduction. I also want to just say thank you both for your attention at this late hour for you and giving me the chance to speak with you today. I hope that this talk can be both informative and spur some interesting discussions afterwards. Let me share my screen quickly here and we'll get started. Hope everyone can see. Yes? Good. So on to the first slide here. I think it might be worth spending a little bit more time on this slide than I normally would, because it sounds like it's very much in the chairman's sort of goal for promoting the idea of intellectual property, especially through the university system, and given the high academic mindedness of the current participants in this. So I want to talk really quickly about, try to answer the question, what is the point of intellectual property? What is the point of patents, and is it a good thing? So the United States Constitution actually tries to answer this question. We put into our Constitution the reason why we have a patent system, but I do not think this is a unique reason to the US. I think that this reasoning should be shared through all free market societies and economies. And that reason is, you see on your screen, to promote the progress of science and the useful arts. And the way that we do that, the patent system's answer to this, is to grant a limited monopoly in exchange for the disclosure of the knowledge of how to make, create, and develop that technology to the public. So I think a good way to think about this is in counterpoint. So if we didn't have a system patent system, how would people deal with intellectual property? And I think the most likely answer to this question is trade secret. Trade secret, to borrow a philosophical term, would be the sort of state of nature for intellectual property. And a trade secret basically just means we don't tell anybody when we make an invention, when we make a new product, when we have innovation occur, we just try to keep it a secret. We don't tell anyone. Maybe we even build in protections to protect against reverse engineering. We hoard and hold close to our chest these new ideas and try to make sure no one else has them. And so the question becomes, which of these is better for society, right? And I think most people, when they think of this and look at the examples, conclude that the patent system is the better way forward, because when run well, it creates this environment that promotes innovation to occur. It provides an incentive, and both monetarily and philosophically, to create and market new things, while at the same time requiring that in order to obtain your protection, your economic protection, you disclose to the public how you made the thing, how to use the thing, and the scope of the thing, right? So maybe we even include some examples. But it is required that one of ordinary skill in the art in this particular field be able to make and use your invention, or else the government won't give you a monopoly right to it. Another useful way to think about the patent system is a kind of contract between the government and its innovators. The government says, innovators, you tell us how you came up with this new idea, how it works, how to make it, how to use it, and then tell us what scope of property right you're asking for. We will have a reasonable debate back and forth and hopefully come to a scope of property right which you deserve, and we will grant you a limited time monopoly so that you can make back your investment in this, and hope maybe even a little bit of profit that you will hopefully sort of reinvest into more innovation. And so we hope that this virtuous cycle occurs where we are making money, we are gathering resources, while at the same time giving to the world new things at an ever increasing rate. So that would be my answer to why we have a patent system, why it's a good thing, why you should want to be involved in it. And so once you make that decision to become involved in it, I think it's worth moving on to the more practical thing, which is, what are the goals when you are taking a single application or a portfolio and looking to obtain intellectual property over it? And those are the goals you see on your screen now. The first goal is to protect commercially valuable subject matter. Again, we don't care about subject matter that's not commercially valuable, right? Because a patent right is the right to exclude others from making and using an invention. It is not a right, a positive right to allow you to do anything yourself. So you don't need a patent to do anything yourself. You just need a patent to forbid others from doing something. And so if it's not commercially valuable, if it's not something other people want to do, then we don't really care about it. It's important to keep that sort of in mind as you are deciding whether or not to make a filing or not, and also when preparing your filing. The other thing we want to keep in mind is maximization of our return on investment. Again, this is sort of an economic instrument here. This is a piece of property. And so if we are spending more on obtaining the patent than we are getting from the patent, this is no good. This is a losing proposition. We don't want this. And what this means is having a good plan in place for how we are going to recoup resources from this intellectual property instrument, and also making sure that obtaining it is efficiently done. So with those things in mind, let's move on to the how-to, the practical side of this. So the first thing we need to make sure when we are crafting our portfolio, especially if we're keeping a global market in mind, is that every portfolio needs a captain, a point person, a central figure who's going to be in charge of things. And that central figure's main responsibilities are are going to be to provide a global prosecution strategy, ensure that it is strong and each individual jurisdiction maximized, and also to ensure that we have consistency as much as possible across the various jurisdictions. Lots of things go into this. Each jurisdiction in the world, again, patent rights are done by a nation state. There's no such thing as like a global patent. Europe is trying to have a sort of regional patent now with its unitary patent system, but it's still a nation state right. And those nation states have different rules that you need to be aware of, or at least your captain needs to be aware of. These are all things that you should consider. What technology? Where are you going? What order? Sometimes the order of filings can be significant. And I have on here, a plan is not a strategy, right? We want to make sure that the person in charge has contingencies and what if things go wrong, right? To know where to go and how to pivot in various cases. We talked about this a little bit before, but this is a more tangible questions you need to be asking yourself about the purpose of your filing, which is, what kind of filer are you? Are you going to be suing people in court? Are you going to be, I'm assuming with this audience is the second one is probably the most likely. Your revenue is going to come from primarily from licensing, but you never know if you might have to end up in court to enforce it. And then there are these tertiary things. For businesses, sometimes they want to raise their business evaluation. Obviously, that wouldn't be necessarily for you guys, but maybe you're looking to get grants, right? You're looking to show and prove to the government or the powers that be that you are an instrument of innovation, that you are pushing your areas of technology into the future and forward. And so patents can be a useful way of accounting and proving that innovation is occurring. So the other thing that the captain needs to make sure that everyone is aware of is that there are different rules and risk. There are different tricks and procedures for different jurisdictions, and enforceability rights may be different. And for you especially, you need to keep in mind for each individual jurisdiction, what is it that you need in order to be able to sell that license, to get that license? These need to be always on the forefront when you're making any decision in an individual case. Keep these things in mind. And then the last is consistency. You need to understand that while patent rights are local, prosecution is not. Patent examiners from across the world look at each other's work. They sort of copy rejections. We see it all the time. So every time that you respond, let's say, and you go to Korea, right, and you respond to an office action in Korea, well, the examiner in Europe reads that. The examiner in China reads that. The examiner in the US and India back home is going to read that. And so if you say something that is inconsistent or isn't furthering your goals globally, that might be held against you. It's not just the examiner either. So if you want to appeal things, potential infringers and licensees, they can all see this stuff. It's all public. So you want to make sure that you don't get myopic, tunnel vision when you're going through prosecution in any one jurisdiction that might harm your global portfolio. And so lastly, formalities also matter. Different jurisdictions have different rules. India has very strict formality rules, especially when it comes to disclosure requirements, which leads us nicely into the next slide, by the way. India and Israel have two of the most demanding IDS, information disclosure statement policies in the entire world. They want to know, has any piece of prior art ever been cited in any other jurisdiction? They want to know the reason that it was cited. They might even want to see the arguments presented by an examiner somewhere in the world who gave any reason why you should not be granted your patent. And they are messing this up comes with very real penalties. Your patent can be invalid by if you found later on to have failed to meet the disclosure requirements of any one jurisdiction. So it's important to maintain these. You also have to keep in mind, once you get a patent, you can still mess things up. What happens when you transfer the asset to someone else? What happens when the inventor moves on, right? A lot of times we'll find a decade later, we do something with the IP and we need the signature of the inventor, and nobody knows where that inventor is, right? He or she has moved on to other things. Maybe they're in the private sector and no one can get in touch with them. And this creates major problems and major expense. Remember back to our first principles. If we're spending more on our IP than we are generating, we have done it wrong, right? And so just as in maximizing the value of each patent is important, minimizing unnecessary cost expenditures is equally important to make sure that ratio stays in the positive. All right, so talk a little bit about strategy here. Technologies are treated very differently around the world. Biotech is really hard to get in the United States right now. This is a huge problematic area. Computer science, depending on what jurisdiction you're in and the beliefs of that community, can have different, very difficult hurdles to overcome when you're trying to obtain a patent. Pharma, depending on your jurisdiction, can be looked at very unfriendly and have extra hurdles to jump over. Pure chemistry and mechanical and design tend to be a little bit more, let's say, the neutral playing field. Everyone tends to treat these a bit the same, but regardless of technology area, there can also be some differences. For example, if you are looking to file in both China, Europe, and the US, 3 major jurisdictions, you have very important timing requirements to think about. China rewards early filing. They want to see, China rewards late filing. Europe and America reward early filing. Europe and America want you to get your application in, and they'll allow you to supplement it with post-filing data, maybe, or some extra declarations to show more experimental data. China won't let you do any of that. They want to have everything on the plate at the time of filing. They want to see examples, and they're very unlikely to give you much more scope than you have exemplified in your patent. And so you're torn between this strategy of filing early or filing late, but making sure you don't wait too long that some of your disclosure may leak out into the public. And now in a place like Europe, where you have no grace period, you have no protection against an early publication, let's say, that you lost control of, now you're losing rights in Europe that you could have potentially had. And so there's this very important weighing of strategy when it comes to, I've got this new invention and I'm still working on it, but it's ready to go in some ways. And I need to make sure that I don't lose rights in one jurisdiction, but I don't forfeit my ability to gain rights in a jurisdiction like China because I waited, I didn't wait long enough. So these are important things for the captain to manage. Global network is very, very important to the captain. You do not want to be going to a jurisdiction for the first time with no contacts with an important invention, right? So whoever this captain is going to be needs to have a network of people around the world who are trustworthy, who are reliable, and who are, affordable, I guess you would say, economically reasonable to work with. I have filed in every possible jurisdiction in the world, including, for example, the Bahamas, which nobody files in. I'm pretty sure the Bahamian Patent Office is a post office with a guy in the back who stamps patent applications. But it's important for my practice that I know someone in the Bahamas in case I need to make that filing, right? This is critically important. You do not want to be scrambling to try to find someone who knows even how to file a patent application when it comes time to make that move. And then lastly, on the last slide, which I think we're about out of time, I will encourage you to be flexible and willing to change midstream, right? Some things are going to work in India that don't work in Japan. Some things are going to work in Korea that don't work in Canada. right? So we have to be adaptive and always keep as our North Star, as our guiding principle, what we talked about in first principles. What is that commercially valuable subject matter? How can we best protect it? Everything else is kind of secondary to that. All of our planning, all of our strategy must always ultimately point back to that North Star, which is the maximization of the protection of our commercially valuable interests at a reasonable rate, right? To maximize our ROI. So it's tough to do this in 20 minutes. I hope that we're happy with what I was able to achieve there. I hope it's provoked some questions in your all's mind that we can now talk about. But yeah, so that concludes my presentation. I hope right on time. I'm watching the clock over here, but Chairman, I hope that was suitable for the audience, and I'm happy to answer any questions that you may have.
Right. Thank you, Rian, for a wonderful exposition. It was very, very clear. We have more than 230 people who have joined on the Zoom platform, perhaps
Wonderful.
several hundreds watching on our social media platform also. We will definitely open up the session for a few questions. But before we open up, I have one general question that as academicians, all of us, we face this dilemma, because in the academic world, we put more emphasis on publishing our research results in top journals. On the other hand, there is also a need to patent the knowledge that we create. So how can we strike a balance between these two?
It's a fantastic question. Universities all over the world face this same question. And I think an analysis needs to be done as early as possible. Anytime an invention comes to the forefront, anytime new knowledge is brought forth, ask the question, what is the commercial interest here, right? So is this something that we have a viable path to receive economic resources for, be it licensing, or I guess way less commonly in the university's case, you're going to actually develop and sort of market a product. My guess is almost exclusively the pathway is going to be through licensing. And so the question of whether to file a patent application or not is ultimately the question, do we have a viable path to licensing this and receiving at least equal, but hopefully more resources in return than we are going to expend to obtain our property right? So I think that has to be the question. And if you answer the question yes, then file your application. If you answer the question no, then don't. Just go ahead and publish your research. Publishing can be important not only for the university aspect of it, but it also puts into, you're essentially donating this invention to the public, right? So no one else is ever going to be able to file a patent application on this once you've made your publication known to the public. And so that's ultimately the question. If this is a viable path towards economic resources, making money, positive ROI, make your filing. If there's not a viable path, just go forward with your publication. That's what my advice would be.
Okay, thank you. But there is a related question, Rian. We all want to encourage technological progress to enhance the quality of life and standard of living. But on the other side, we also want to promote patenting and protecting our intellectual property. And in that process, what we do is we are letting only a small group of people own this knowledge. And don't you think between these two requirements, how to draw a line and ensure that the human progress is not impeded because only few people have access to knowledge?
Well, so that's the greatest thing about the patent system is everything is public, right? Mm-hmm. So when we file a patent application, this is something I tried to mention at the beginning of the presentation. When we file a patent application, that becomes published. And as soon as it's published, it's available to the public. Other people can now stand on your shoulders and continue to innovate. In fact, that's what happens in the marketplace these days, is most of the time, an invention, the entire patent term of a particular patent to protect an invention rarely gets used because the person brings the product to the marketplace, other people look at the product, review the disclosure, and then build upon it and make a better thing before the time limit runs out. So most people end up just sort of giving away some of their patent term at the end because someone else has invented a better product. I think this is a great thing. This is how we want things to progress. We want to increase the speed of innovation. Now, hopefully that person in that sort of limited time window was able to recoup their economic investment, right? But to answer your question directly, the patent system is not an impediment to, it doesn't hoard knowledge. It doesn't hold knowledge close to its chest. It reveals, it publishes, it promotes that knowledge to the public. The alternative, trade secret, is the thing that I would worry about. The thing that would be counter to an academic institution's core mission, I think, would be exactly what you said, to hoard that knowledge and keep others from knowing it. Now, again, here, there needs to be a distinction that's made. When you patent something, you are not restricting people's ability to know about it, to think about it, to use the information. What you are restricting is very specific. You're restricting their ability to make, use, or sell it, right? So they can't make money off of it. If they want to produce a good from your innovation, they need to pay you a licensing fee. But they are free to think about and use your information to develop their own version or a better version, which does not entangle itself in your property rights. It doesn't meet the claims of your particular patent, right? So again, the object of the patent system is to spur innovation, to spur creativity, to spur collaboration, while at the same time and narrowly only protecting economic interest, which is why I focus so much on this idea of ROI, on return of investment, because if you're not getting that economic benefit, then you might as well just publish, right? Because publishing does the same thing that filing a patent application does as to the public, right? It tells them about your new scientific progress, about your new invention, and allows them to build off of it and make the world a better place. But it doesn't come with a potential economic benefit. And so that's the real big difference. That's the dividing line. Now, you have to take a broad view. You have to take a futuristic view, right? Maybe you want to file a patent application that you don't think is necessarily licensable now, but it's the beginning of a portfolio where a combination of patents, when put together, suddenly does become licensable. And you want to maintain your ability in the future, maybe to continue developing this technology to a point where licensing is viable. So I just want to more broadly say, you can't just look at a single application. You have to think about the invention as a whole. And when you're deciding whether or not is it worth the investment to file a patent application or not.
Excellent. Your answer very clearly removes any possible misconceptions about patenting. Very nice. You also mentioned about artificial intelligence in your slides. A philosophical question surrounding the artificial intelligence. If any new ideas are generated using the artificial intelligence, which are worth patenting, is it the developers, or is it the AI machine, or somebody else who owns these ideas which can be patented?
So you asked the question that will get any room of patent attorneys going crazy, right? So this is a big question right now. I can virtually guarantee you that the system that we end up with is not the system that we have right now. So right now, what we've had is a few jurisdictions, including Europe and the United States, come out and say that artificial intelligence cannot be an inventor. So you cannot file a patent application in the name of an AI. Right now, what's happening is the people who develop the AI go on the application as the inventor. But plenty of people are asking similar question to what you did, which is, okay, what happens when AIs become so sophisticated, which they already have in some instances, where the person who develops the AI loses understanding of how an AI comes up with the answer that it comes up with. We call these black box applications. Essentially, the inventor of the AI says, well, I programmed the AI to do this type of machine learning, or look at this database to train itself. And then I ask the AI a question, and the AI gives me an answer, but I no longer have any idea what processes the AI went through to give me that answer. I just know that they gave me an answer. And when I test the answer, it looks like a pretty good answer, right? So what do we do in that circumstance when we kind of have a hard time fulfilling our contractual obligation to the government in our patent contract, where we have to tell everyone how we made our invention and how to use our invention? Well, this is a problem for a black box AI because no one knows how they got that answer. We can't explain it. And so for those, I think this is going to be, we don't have an answer, is the sort of, the patent community hasn't come up with a good answer to this question yet. We're going to have to come up with an answer to this question in the future. And it's going to be, the problem we're going to deal with is, what do we do with an invention that we know works? We know that when we ask the question, we get a good answer, but we don't understand the process by which we came to that answer. So in patent terms, we would say there's a written description and enablement requirement in order to obtain intellectual property rights. We must demonstrate that we had possession of the invention, and also we must describe it in such a manner that one skilled in the art can repeat our results, right? Can we do that with a black box AI, type of invention, type of application? That is an open question. Philosophically, personally, I don't really have a problem with an AI being an inventor. This is something that a lot of governments have really said strong no's to, but from my point of view, I don't really understand why that would necessarily be an issue. But I think it would solve some of these enablement sort of requirements, as to being able to say, well, who actually made this thing, who gets credit for it. But that is not the way that things are going. It's unlikely that will be the way the future goes. So my guess is that some accommodation is going to have to be made. People are either going to say, we want AI inventions, we want to have them participate in the patent system, because again, what is the alternative? It's trade secret. Do we want that? Is that a good space for this technology area to be in? I would say very clearly not. We want as many technology areas as possible to participate in the patent system, because I believe, and I think in most free market societies, this is ultimately found to be true, that participating in a patent system increases the rate of innovation, increases the cleanliness of it, and makes everybody a little bit better. And so because of that, if we keep that as our North Star, we need to figure out a way to have AI also participate in this space. And yes, some accommodations might need to be made. These are the big questions being asked right now. And AI is developing incredibly fast. Let's see if governments can keep up.
Right. I think this is also an important issue of, you can't find solutions to such complex problems working in silos. I think AI technologists, philosophers, social scientists, policymakers, all of them have to work together to find answers to such complex questions, perhaps.
Yeah, I think you're right. And, there's people on both sides of this, right? We have even religion comes into this quite frequently. I see it in the biotech industry space a lot, and in the computer science space. In computer science, people tend to think of it as replacing what is going on in a human mind. And if you hold that connection of neurons sacred, then AI starts to feel like an attack on belief systems. Whereas in biotech, we are talking about the building blocks of our body, right? How our bodies work, how they function, maybe all the way down to our genetic code. And for some people, that feels like an attack on their sort of being. I've heard people say on their spiritual being, right? And so biotech and computer science are kind of unique fields because we've seen government organizations start to weigh these sort of philosophical questions, put them counterbalancing what you would never see if we were just trying to patent like a car, right? And so it's worth knowing at least that these are the type of considerations that go into the policy around AI patenting and inventing, that people are thinking about these even religious issues when it comes to setting public policy and deciding if we're going to go forward and how we go forward with protecting inventions that come from, for example, AI. And so, yeah, you can't undersell the complexity of this question, right? It is one of the it's certainly the biggest question in my field, but it's a very human big question to ask and answer, right? You see it in if you read science fiction, the question of what it means to be a human and how do we divide between a general intelligence AI and a human being? Like, what becomes the difference? That becomes a real type of question. And so how we decide to move forward on this has to take those things into account. And it's anybody's guess which side we're going to fall on. I find it highly unlikely that it will be impossible to patent AI inventions in the future, but maybe it turns into some like second class patent, right? Where it's harder to get the patent rights, or they're more restricted in some manner. Maybe we invent a completely new instrument. This is very much on the table, by the way, creating a new instrument for protecting AI inventions or innovations. So, we have copyright to protect arts. We have trademarks to protect businesses' identities, and we have patents to protect inventions. We might have a fourth category of intellectual property, which has to do with AI. Not only what AI creates, but also the AIs themselves. Another big question, which we haven't touched on, which you can talk about for hours, is should people be able to own AIs? Are they themselves property? And once an AI becomes sufficiently sophisticated, does that bring on moral problems, right? So how much time do you have, Chairman? I guess is the question back to you.
No, it's a very interesting conversation. We are past 9 p.m. in India, but I see still nearly 200 people on the platform. I'm sure they also have some questions, and if you permit,
Absolutely.
we'll take some questions from the audience also. I request my technical team to please unmute, and the audience, you can raise your hand electronically. We will see on the screen, and we will let you unmute so that you can put your question. So there is a question in the chat box.
Yeah.
He says that the patent at the most is protected only for 20 years. So the question is, how do you suggest for technology transfer?
Okay. So you're right in most cases that there's certainly a limited term, and 20 years is typically the term that we would get. There are some things that you can do with portfolio development that you might be able to stretch that a little further if you needed to, but that's probably not the point of this question. When it comes to tech transfer, what this means is you have a time horizon by which you can recoup financial investments on this. So when you are selling or licensing your patent, you just need to account for the fact that this is not a permanent situation, right? It will be time barred at some point. That sort of flow of resources is going to expire, right? And there are, depending on how valuable and how long lasting it is, for example, in the pharma industry, this is where we see patent terms stretched the most, because the end of a patent term of a particular drug tends to be the most valuable. So we tend to look at it, patent term being most significant to pharma. But it becomes an accounting problem, right? So this is how long my patent term is. This is how much it costs to extend it that far. At what point, maybe you make a graph on like money earned versus money spent. We want to make sure that we don't cross to the wrong side of that graph when we are performing our licensing agreements or even making our decision on filing as best we can. We always have to do this with imperfect knowledge. No one knows the future. No one has a crystal ball. So we do the best we can. But these are the considerations that tech transfer should take into account when considering patent term. I hope that I answered the spirit of that question.
Right. Now there is another question here. Thousands of patents are filed every year, but many of them, they do not see the light of the day. Is it necessary to file patents at all? Because only few patents are ultimately successful.
That's objectively true. The reason that I would say, when you say patent successful, what you mean is the patent protects a commercially profitable invention. And the reason that is whether or not the underlying invention is successful in the marketplace has only a little bit to do with the patent, right? So what the patent's job is to create an environment which makes it easier for you to exploit your economic gain in the marketplace. It says you are the only person who can make and produce and sell this innovative good, this invention. No one else can do it for a certain amount of time unless you sell that right to them, right? So it gives you a profit stream maybe through licensing, and it also allows you exclusivity in the marketplace, which gives you a huge advantage, right? We all can agree that monopolies are a good thing to have. They make you lots of money. But the reason that they don't succeed, these are just conditions which help you, right? If nobody wants your product, you may have an invention, but no one wants it, so you're not going to make any money on it. That's why, again, I try to spend extra time on these first principles, one of which is, do you have commercially valuable subject matter? If you don't, you can invent something that's not commercially valuable. That's a thing that people do all the time. And so I would say, again, I tried to answer the chairman's question, where is the line between what we file a patent on and what we just publish on? If it's not commercially valuable, yeah, there's not really a point in filing a patent application on it. Unless, again, of course, it leads you to a path to, you're protecting a large sort of swath of information, a portfolio, which ultimately results in something that is commercially valuable, right? But to answer your question, yeah, if it's not commercially valuable, you wasted money. Don't do that.
Yes. Mr. Ashwini Sival, could you please ask your question?
Yeah, good evening, everyone. Thank you for providing this opportunity, Mr. Chairman. Rian, I really appreciate your lecture and your expositions on global IP and strategy. I just want to ask a simple question. We are facing a very difficult conundrum in the universities, where researchers of the universities are, creating different products and processes, and they are, independently seeking patents. They are not preferring universities to be the co-patentees with them. So this is one very fundamental problem we are facing. I am myself is a coordinator of a patent course at University of Delhi in the Research Council of University of Delhi, and also a part of the research and development cell of the University of Delhi. So this, how do you see it globally? I mean, what is the best practice when it comes to co-ownership or co-inventorship? Which jurisdiction you think is the best, which we may refer to imbibe into our strategy or to meet our needs in India?
Yeah, so the
Right.
way that other universities, like for example in the United States and Europe, I know for a fact because I've worked with them before, the way that they address this problem is through contract. If you are enrolled at a university, if you are an employee of a university, in your contract to matriculate there or to work for them there, in your contract there is a specific provision that says any invention that you come up with using university resources, meaning you've used our equipment, you worked on it in the lab that we provided you, anything that you've done while on campus using our stuff is our property. In the United States, we have a doctrine called work for hire, which means that if I pay someone money to like conduct experiments for me, or I give them instructions and say, please execute this thing, then the product of the intellectual property of their labor belongs to me, not to them. This is how corporations, by the way, everywhere, they also have a similar provision in the contracts with their employees that say if you invent stuff while working for us, it belongs to us. It does not belong to you. It's why most of the patent applications that I file are filed with what's called an assignment. So an assignment says I transfer my rights as an individual to a entity, either a corporate or university entity. And the reason that the inventor signed that is because they're obligated by law to sign that because it's a part of their employee contract. So my suggestion to you, as long as there's no prohibition against this in India, would be to include such a provision in your own contracts with your employees and with your grad students and with even the students that are just members of the university that may be helping with sort of maybe the grunt lab work that occurs, right? Is to say, look, guys, if you're working with our stuff, then the university is at least going to be a partial owner. Again, you can contract however you wish. If you want to, like, for example, in Germany, there's a very strong inventor's rights. And so the inventor is they have the right to obtain a certain percentage of the money that comes in through something that they invent. Whereas the United States, we don't have any of that. It's way better to be an inventor in Germany than it is in the US, let me tell you. But that's up to you. But the answer to your question, I think, is through contract. You need to have a contract with your members, your innovative members of the university, to define what relationship it is that you want between university and actor within, and professor within, and researcher within, right? But that's the way the rest of the world does it, and I think it's generally pretty successful. So that would be my encouragement to you. I hope that addresses the question.
Yes.
Okay.
We'll take one last question. Preeti Suresh, could you please unmute yourself?
Yes, thank you, sir. Thank you, Chairman, sir, for this opportunity. My just query is like, can the academic institutions use the PCT pathway for filing the patents in multiple countries?
Yes, they can. PCT is open to any filer, and it's a great resource. It's especially a great resource to delay the decision of where you want to file. So I would say a PCT user is one that has a valuable invention that is up against the deadline. They need to make a filing. They know they want to file internationally, but they don't know exactly where, right? They don't know how many countries they want to file in or where they want to file. PCT is great because it delays the time in which you have to make that decision. It puts it down the road, which can be incredibly useful in various situations. If you already know exactly where you want to file, I'd say don't bother with the PCT because it costs more money, right? So it's just going to increase the cost associated with it. But yes, your question was, can you? You absolutely can. Anybody can file through the PCT, be you a university, be you individual, be you a business.
Great. There is one question that has come to me. He asks, can a theoretical invention be patented, such as in mathematics?
Yeah, so this is another sort of first principle. The difference between discovery and invention. And you run this in biotech a lot too, trying to patent something that may be viewed as already present in nature, right? So the short answer to your question is no. Mathematics is classically not patentable because it is understood as something that is discovered, not invented. And so where we see mathematics, something that looks like mathematics trying to be patented, is in the computer science space with algorithms, right? So the thing kind of looks like a math equation and we're trying to patent it. But what we're actually patenting is the function of the algorithm, right? So you might say to yourself, oh, well, a computer system is ultimately just a series of equations. But in real life, what we're patenting is the function of that thing. So the function of that system is to, output certain commercially important computer task, right? In the case of like a blockchain, maybe. So like, yes, there's a bunch of mathematical formulas underlying it, but the function of it is to provide this sort of secure network of information transfer that's both public and also sort of protected. And so that the functionality of it is patentable. The underlying math is not patentable. It is tricky, but if you can think of it that way, discoveries not patentable, inventions are patentable, and I realize that can be some gray area between those things.
Correct. Absolutely. Rian, I think we have taken close to about 52 minutes from you.
I'm happy to be here. It's late where you guys are. If you want me to stay on and ask your questions, I'm happy to do it. But I understand at some point, all good things must end.
Oh, in that case, I will take a couple of more questions. Dr. Acharyulu, could you please unmute yourself?
Sir, good evening, sir. Thank you very much for the excellent information provided so far, sir. My question is related to how to ease the process of commercialization the given patent, sir. It's been a cumbersome process for the past years. May I know your expertise, please, behind this? Thank you very much, sir.
So, Rian, what he's saying is there are a lot of bureaucratic steps in patenting, and that puts off many academicians.
No, it's fair. And those aren't the only impediments, right? So there's two processes here. There's one is getting the patent, right? So making sure you've got a competent professional that you're working with that efficiently helps you obtain commercially valuable patent rights, right? That's the first process. We got our patent, but then we got to monetize the patent. That's a completely different thing, right? So you almost need a different, not almost, you do. That's a separate network of people. You're not really going to find patent attorneys that are also experts in commercialization of inventions because that wouldn't really make sense, right? So the business community is very specific to the area that you're in, more specific than a patent attorney is going to be. And so, unfortunately, the answer I have to give you here is you need to develop connections and a network in the business community that can bring your invention in front of people who are potentially willing to invest and commercialize that invention. So what I would say, a lot of universities in the United States specifically have put in lots of efforts of developing venture capitalist networks and also networks with large corporations in this area to say, we have these great inventors here. We are producing valuable technology. Here is the portfolio that we have. Is this valuable to you? Let's have a conversation about how much it might be worth. So you literally have to shop these things around, but having that network of VCs or corporations there that can provide buyers for that which you are selling in the form of a license is critically important to a healthy sort of tech transfer office at a university. You might consider, because the university system in India is more cooperative than some other places, you might consider teaming up with other universities to provide such a network, right? And you can sell it as an opportunity to local venture capitalists to say, like, look, this is a great area for investment for you. There's a lot of really great innovation occurring here that you could potentially make lots of money off of. and let us have a quarterly demonstration of the things we're working on. You can present it to those who are looking to invest, and this is be a great interchange of opportunities here. The university wins, the private sector wins, and everybody's better off for it.
Thank you very much. We have a Vice Chancellor from Mizoram University. Could you please?
Yes, sir.
Go ahead.
Yes, Professor D.C. Dekka. One question is coming to my mind. If my invention is patented in India, is not my right protected in all other countries? Why I should go for multiple patenting in different countries? I have patented my invention in my country, in India. Why should I? So my rights should be protected globally. What is the answer?
Well, where are your markets? So if all you want to do is sell in India, then yeah, don't file anywhere else. If the Indian market is sufficient for your needs, then make your filing in India and proceed amongst your day. But if you're looking to make money in the United States, or you're looking to make money in Japan or China or Korea or Europe or anywhere, you need to have a patent in that jurisdiction, or otherwise you have no protection, right? So anyone can compete with you, anyone can copy your invention and sell it as their own. In a place like China, that's particularly difficult because you can best believe that some knockoff will immediately appear at a quarter of the price that you're producing it. So the question back to you is, where are your markets? And anytime I'm advising a client and they ask me, where should I file? The question I ask back to them are, where are you making your thing, and where are you selling your thing? Those are the markets where we need protection, where we make it and where we sell it, because those are the two places where we would likely enforce it. And those are the two places where our revenue is coming from. Again, I got to keep going back to that first principle. What we care about is valuable commercial interest. And so anywhere where you are receiving a commercial benefit, it behooves you, it's a good idea to make sure you have protection in that jurisdiction. Patents, of course, need to be thought of as globally, but they are only enforceable on the nation state level.
Right. We have Ekata Mehul. Could you please unmute?
Yes. Good evening, and Ryan, fantastic understanding of this. I have been into academia and now in corporate. So I have 2-3 questions. One, I have a patent on my name right now, but it took me a lot of time for when I published it and before it actually got awarded. What happens during that time? If somebody else makes a product, what is during that time if somebody else make a product? Can I claim that? Or
yeah, so now the world has sort of unified to a system which we refer to as a first to file system. The United States used to have a first to invent system, which was a little more complicated, but we don't have to talk about that anymore. It's a first to file system. Okay. So what we care about is, what is your filing date? When did you make your very first filing with some patent office somewhere in the world? Okay. The person with the earliest date is the only person who even has a chance to obtain intellectual property rights, to obtain patent rights over that disclosure, right? So if someone comes in 6 months later and they just happen to invent the exact same thing that you did and they make a filing, yes, it may be a little confusing for a little bit until both jurisdictions figure this out. But ultimately, what's going to happen is the disclosure is going to be looked at, the claims are going to be looked at, and they're going to say, who's got the earlier filing date? And the person with the earliest filing date wins. So that doesn't mean that you're going to necessarily receive a patent, but what it does mean is that nobody else is going to receive a patent. As soon as you make that filing, you can be assured that no one else anywhere in the world will ever be able to get a patent right over that which you have disclosed, unless they filed before you. But like going forward, no one will ever be able to do that. That right, if it is going to exist, will be yours.
That's really good. And since we have a lot of academicians here, I would definitely, I'm calling up from Sientra, Bangalore, and we are a company. We deal with VLSI and embedded systems and software, and we do a lot of intellectual properties, internal development. So I want to also pose this question: that what if a university and a corporate needs to do a joint patenting?
Yeah, that's no problem at all. Right. So there is, when we think about patents, there's like the question of inventorship, and then there's the question of ownership. Inventorship is an objective determination. Who meaningfully contributed to at least one of the claims? The claims are the thing which you're asking the government for protection over. So who made a meaningful contribution to that? If the answer is yes, then that person is listed as an inventor. If the answer is no, that person is not an inventor. Ownership can be whatever you want. So the university and the corporation are free to contractually decide ownership of that patent in any manner that they want. So you can have the university own it and license it back to the corporation. You can have both of them own it, and that gives them both the right to license to other people. It's whatever you want. There is no limit on how you divide or the power over that invention, the ownership over that invention, who's allowed to do what. You can do whatever you want. Whatever both people agree to will be recognized. And so, yeah, you see a huge diversity of arrangements. You may say, yeah, for example, the university has ownership of it, but the exclusive right is transferred to the corporation, and the corporation is responsible for enforcing that right, and they split the profits 50-50, or they split the profits 60-40. Whatever you want. You can split the profits however you want to do it. So, yeah, you've got a lot of flexibility there when it comes to how you want to sort of work together. And then on top of that, there is a system in some jurisdictions. It's called a joint research agreement. And this entitles you to sort of special rights if, let's say, your corporation and a university are working together under an agreement to develop a technology. So that happens in the invention space. Many jurisdictions will treat you as one entity as it comes to that particular invention. And that can have some benefits for portfolio development, because your own prior art in most jurisdictions, you get a grace period for it, so it is less likely to get in your way. So in special circumstances, you can do what's called a joint research agreement, and maybe it helps you on the invention side of things. But that's kind of a complicated area there too, which is only tangential to your question, I think.
Rian, there is one more question. Professor Ramesh Goyal, could you please unmute?
Sir, I want to know that there is a risk of confidentiality being lost sometimes, because there is infringement in the patents that happens at times, especially in the pharma. So how will you comment that, like, some abstracts are always, when you file the patent, it is published. So some of the secrets may be out. How will you prevent, or how will you assess these risks?
Okay, so I'm understanding the question as the interplay between patenting and trade secret, right?
Yes.
So, yeah, okay. So these two things don't mix well, is the short answer to that. We do not want to put trade secrets in a patent application. That'd be a bad idea. When you put a trade secret in a patent application, it ceases to be a trade secret. This is going to be published. It's going to be available to the public, regardless of whether you get a patent right or not. That trade secret's gone. So whenever we are dealing with an invention which is kind of 1 foot in trade secret and 1 foot in patenting, we have to ask the question, can we obtain patent rights, commercially valuable patent rights, without the use of that trade secret? If the answer is yes, then let's keep them separate. Let's treat one like oil and the other like water, right? Keep them forever separated. If we can't, if you need the trade secret in order to, let's say, satisfy the enablement requirement, satisfy the disclosure requirement in order to obtain your patent rights, then we have to make a decision. Our decision is, do we risk the trade secret by putting it in the patent application? If that's an acceptable risk, then that's probably what we do, because in almost every case, it is going to be superior to have a patent protection than it is going to be to have trade secret protection. The only advantage that trade secrets provide over patents is that they are an indefinite term, so they could theoretically last forever. But people are very good at reverse engineering. People are very good at discovering these things. It's very easy to leak. So in almost every case, it's better to have a patent than a trade secret. But obviously, when you apply for a patent, it's not guaranteed that you're going to receive it. So you're going to have to make a decision, which you can't take back. Do I risk the trade secret and put it in the patent application? Or do I not willing to make that risk, and so I don't put it in the patent application?
I personally feel both are linked. It cannot be separated.
Well, in that case, you've got a decision to make then.
Right.
Yeah, no, you're going to have to decide, do I risk my trade secret knowledge by putting in the patent application? Because I have to if I have any hope of obtaining patent rights. And am I okay with that being a time-barred monopoly that I'm going to receive protection for? But keep in mind that patent protection is much more robust, and you can sell it. Kind of hard to sell a trade secret, right? You can do it in theory, but it's rather difficult. And so a patent is much more easily monetizable, much more easily protected. It comes with better consequences if someone violates it. It's really superior in every way. And getting back to our first principle, you're a university. I would hope that you care about sort of furthering human innovation, knowledge, and progress. Patents offer the information to the public without holding it to their chest and keeping it secret. Trade secrets do not. Trade secrets hoard knowledge and keep it from other people and keep them from being able to use it. And so from a philosophical perspective, I would say the universities would have more of an interest in at least trying to get those patent rights, because they're not having to sacrifice their sort of duty to the public to educate its citizens and promote the advancement of humanity. So
Absolutely. You're very right there. We have Professor Kavita Thakur. Could you please unmute? Professor Kavita Thakur, could you please, please unmute again.
Yes, I have one doubt. What are the key considerations when managing IP across various international borders?
I'm so sorry. You cut out a little bit. Would you mind asking that question one more time?
One more time?
Yes, just one more. I didn't hear exactly the question. If you wouldn't mind repeating it one time.
What are the key considerations when managing intellectual property across various international markets?
Okay, I heard it that time. Thank you so much for the question. So I hope that the presentation touched on some of these things, but I will highlight them again here. It's important to know that the laws and rules across jurisdictions will be different. So it's very important to understand that the patent rights that you obtain in India will not necessarily be the same as the patent rights that you receive in Korea, which won't be the same as the ones you get in China, which won't be the same as you want to get in Canada or the US, right? So when you are developing a global portfolio and you are thinking about monetizing an invention on a global scale, you need to make sure that each one of these jurisdictions does not lose sight of the commercially viable subject matter which you're trying to obtain, because you're going to have, different sort of bubbles of scopes of protection all over the world, but you want to make sure that all of those spheres of protection overlap when it comes to your commercially viable subject matter. So that's number one. Number two is, remember, we care about return on investment. So you need to understand that in some jurisdictions, patents are going to be way more expensive than in others. And the time horizon matters. For example, a patent in Japan is kind of expensive to get, but it is extremely expensive to maintain. The maintenance fees in Japan are higher than everywhere else in the world, and you'll be paying $100,000 for the last term of the patent if you want to maintain it to its full term. In the US, it's usually more expensive to obtain that patent right, but the maintenance fees aren't so bad. In Europe, your filing is going to be kind of reasonable, considering that you're able to treat Europe as almost an entire continent. But you have to remember that that patents are a nation state right. So when you go to, we call it validation. So once you get your patent from the EPO, the European Patent Office, you will have to validate it in each one of the European countries. Well, guess what? Each one of those countries wants a different fee. So when you go to validate it, there's going to be this mammoth cost that is suddenly thrown at you. And so when you're considering where to go on your sort of global IP journey, you have to keep in mind, what are my costs going to be in these jurisdictions? When am I going to be required to pay those things? And you need to make sure that those time horizons and those costs are lining up with the monetization, the commercial benefit that you're receiving in these various jurisdictions. So you're always matching those things up. You're having to make that decision in each jurisdiction. Is it worth going here? Is it worth going into Canada? Is my market big enough? Is it worth going into Japan? Can I make my return on investment in 10 years instead of 20? Because I know that after 10 years, man, it's going to get really expensive over there. So these are the type of, you've got both sides of the aisle, right? Obtaining it, understanding that your rights are going to be different everywhere, and also the monetization, making sure that it's worth it to have a patent in all these different jurisdictions. So yeah, it's a complicated question.
And every question and your response, they are bringing out new insights in our discussion. But we will have one last question. We will not keep Rian for too long. We have Professor Swarnalata Saraf.
Thank you so much, Chairman sir, for giving me the opportunity for this session. My question is, for a viable product, for the ownership of our country and our university, we go for the Indian patent, and then I want to know how much time it will take for, or can we go for the US patent as the product viability and the product market is there in the US? So can we go for?
So absolutely. Yeah, please do it. So once you make a filing, there's a time limit that starts. You'll have 1 year to make that decision, unless you file a PCT, and you're going to extend it to 36 months from your original filing, right? So there is a time limit where you have to make this decision. But absolutely, you can file a United States patent and claim priority to your Indian filing. And what that means is, when you go to the United States will treat your US filing as if it occurred on the same date that your Indian filing occurred. Now, that's assuming that you didn't add things between the two. You're only going to get information which is supported, we say supported, by the original filing. But yeah, everywhere else in the world, as long as you've met your priority deadline and you've appropriately told them about your priority filing, will give you the filing date, your earliest possible filing date, right? That you've perfected, we say. So absolutely, yes, an Indian filing can be used as the basis for intellectual property filings anywhere in the world.
Right. Excellent, Mr. Rian Paul. It was a wonderful lecture, and also the question answer session, the way you handled and explained in very, very simple language. I hope your recent visit to India was very enjoyable. And next time, if you happen to come to India, please let us know. We will invite you to UGC also to have a cup of tea with us.
Fantastic. Thank you so much for the opportunity. This is, I love talking about this, and the questions were fantastic. So thank you so much. I hope everyone got some use out of this.
Right. Definitely. Thank you very much. Namaste. Namaste to everybody.